Good evening, ladies and gentlemen. Thank you. Welcome to, I think, the second in the series of readers' lectures. I'm self-evidently not the reader. He's been unavoidably detained elsewhere, so he asked me to deputise for him, which I'm delighted to do. It's hard, I think, to think of a more topical subject for this evening than Brexit and the Irish Bar. The relationship between the Bar here and the Irish Bar has always been one of considerable interchange and amity. The relationship between the UK state and the Republic has perhaps had a little less amity, but has always been close, if not necessarily harmonious. One of the lessons of Brexit, which I think has perhaps not been fully digested, either here in London, in fact, or anywhere else, is that the dynamic of many existing relationships is changing, irrespective of how things unfold in the immediate future. And the important learning from that, I think, is that everyone will need to build a greater understanding of perspectives other than their own, if those relationships are to prosper in the future, as I'm sure they will. So with that thought in mind, we are extremely fortunate this evening to welcome Paul McGarry, SC, to speak to us. Paul is a very distinguished member of the Irish legal community. He's the immediate past chair of the Irish Bar and a bencher of the King's Inns. But Paul is also a bencher of Middle Temple, though we don't talk about that here, and he has spent some years in the formative part of his career working in the European Commission. So I think he's perhaps uniquely well qualified to understand perspectives from Dublin, London and Brussels. So it may be pushing it a bit to expect him to know how things will turn out at this very early stage of proceedings, because there's a full 2.5 hours, I gather, before the Brexit Secretary speaks to the House, and indeed there's all of a fortnight to go, so actually anything could happen. But I'm sure he is better placed than most to be able to look into the future. So, Paul, you're very welcome. The floor is yours. Well, you're off already.
There you go. Thank you, Master Berger. It's a great honour to be asked to come here and speak this evening. I certainly wasn't expecting such a distinguished or indeed fulsome gathering. On a Monday night in Ireland, it's very difficult to get barristers, benchers, judges to go anywhere. But it's a great honour for me to have the opportunity to speak to you this evening. I'm sorry if some of what I'm going to say might appear a little basic. I'm certainly not in a position to be able to offer any assistance in relation to what might or might not happen this week or next week or any week in terms of Brexit, to be honest. So what I was going to do was divide my paper into three sections. The first is just to have a quick look at the Irish Bar and how it works and the structure of it, some differences with the way things happen in London, and then to talk a little bit about the common law and how it has evolved and the effect of Brexit on it, and some of the concerns that we in Ireland have about the effect of Brexit on practice as common lawyers, particularly in the context of EU law. And then at the end, perhaps say something about, well, try and say something about what's happening at the moment, as best I can understand it. The Irish Bar is not dissimilar to the bar in England. We're all sole practitioners. Obviously, we operate a library system. Similar ethical rules and provisions to those that obtain in England and Wales. One significant difference is that we don't have any chambers. So if you want to instruct an Irish barrister, you've got to go to them directly. There are no clerks. So all negotiations, engagements and all of that are done directly. Obviously that's a swings and roundabouts issue. You can see the benefit of that in the outset when you're negotiating. You can see the problems at the end when you're trying to get the solicitor to organise to get the client to pay you. But that's the position. It stems, I think, from the fact that the bar was originally relatively small. Solicitors in Ireland are taught and trained in part about the way to instruct barristers, and they deal with barristers on a one-to-one basis all the time. Until perhaps 20 years ago, most practitioners in Ireland would have had relatively general practices. Now there's a great degree of specialisation, but the principle whereby the solicitor can still pick up the phone and make contact directly with the senior counsel or whoever is one I think that they cherish and that they would certainly be very anxious not to lose, notwithstanding the fact that the bar has multiplied in size. We have a new form, although it has been late to arrive in Ireland by comparison with England and Wales, of statutory regulation, a new Legal Services Regulation Act. Although it was passed in 2015, almost none of it has yet been commenced. That's, I think, a function of the way in which our Justice Ministry operates at the moment. It does and will make provision for new types of practice. Barrister partnerships will be permitted. Barrister-solicitor partnerships will be permitted. Employed barristers will be regulated in a way that's different to the way that they're regulated now. But the one thing that we've managed to preserve is that our own club, for want of a better word, which is the Law Library, or the group that's regulated by the Bar Council, will not be required to regulate these types of people. So the Legal Services Authority itself will have to regulate barrister-solicitor partnerships and barrister-barrister partnerships and make sure that they're properly insured and CPD compliant and all of the types of things that we expect. The bar itself, we've 2,200 members, roughly, about 330 senior counsel. The ratio to male to female is about 60-40. Very, very junior in outlook, 60% under 12 years in practice. Lots and lots of pressures at the junior bar, not dissimilar to the way they are here. The issues with regard to getting paid by clients, issues with regard to legal aid, attacks on that, although I have to say it's nothing like as bad as it is in London, certainly on the criminal legal aid side. We have some difficulties on civil legal aid side. And I think one of the biggest problems that we've had in the last few years is trying to ensure that we keep the best and the brightest at the bar. And in the last 5 or 6 years, the Irish economy has grown pretty substantially, and there's been a huge increase in legal business being done by the big law firms in Dublin, and they have been poaching huge numbers of barristers who are qualified 3, 4, 5 years, because in Ireland it takes typically 7 or 8 years to break even from when you start. We don't have a chamber system. Everyone is more or less equal when they start, and some people make it and some people don't. But the biggest problem we have is that the really good ones are now being paid quite large sums of money by the law firms to come and work for them, and they have the benefit of having been trained as advocates and being specialists in certain areas. All training is done by King's Inns. King's Inns has amity arrangements with all of the Inns of Court in London. The bar itself is recognised in legislation. The independence is recognised specifically by the government, and frequently you see our politicians resorting to the use of the bar, and particularly silks, whenever there's an issue or a problem. It's farmed out, much in the way that inquiries are often farmed out to retired or senior members of the judiciary. You'll often find our government ministers saying, well, we've taken advice from certain senior counsel, and therefore you can't blame me for the political mess that I'm making of it if the lawyers say it can't be done that way. We also have a very strong mutual relationship with the judiciary. Most of the Superior Court judges come from the bar, although for the last 20 years solicitors have been entitled to become members of the Superior Courts. They tend not to apply in great numbers for the Superior Courts. Again, we don't really know why that is, but a lot of it I think has to do with the time at which they certainly the ones in the bigger firms, the ones that would be specialists, are coming towards retirement. Presumably they're not interested in doing the type of work that judges do. It's been a difficult, I'd say, 10 years for the judiciary in Ireland, and I know that there are similar problems with the judiciary here. We had a government, not the current government, but the previous government, which championed a constitutional referendum on judicial pay and conditions, which was quite difficult. As a result of that, the judiciary was treated, we believe, very badly. And most people in Ireland couldn't care less about the judiciary. They see them as overpaid in any event. But the judiciary can't really speak for itself constitutionally in Ireland. So we've had some difficulties. We had difficulties getting people to apply for quite a while. Now, in the last 3-4 years, that's changed again, and a lot of the people that have been appointed, particularly to the High Court and the Court of Appeal recently, have been of a much higher standard, and that's kind of, I think, feeding through at the moment to the quality of the judges. So our legal system, as I said, we have a written constitution with a Bill of Rights. Interestingly, there was a lot of debate when we talked about incorporating the European Convention on Human Rights. A lot of our distinguished constitutional scholars and judges thought we won't need to do that because we've got a Bill of Rights and there's really no difference anyway. In a couple of areas, I think proportionality is an example of one. I think in a couple of areas we've seen where there are some additional arguments and issues that have arisen, but largely our constitution, the Bill of Rights would be similar to what's in the European Convention on Human Rights. As a result, the Convention is only incorporated at what's described in Ireland as a sub-constitutional level. So it's only if you don't have any constitutional rights that you can have recourse to the ECHR. Our written constitution is heavily influenced by outside systems that have written constitutions. To a certain extent, some of the European constitutions had an influence on it, but the US Constitution is was quite a significant influencer on it. Obviously, we have a common law system, and I'll be coming back to that in a moment. Stare decisis reigns supreme, obviously Irish courts only. We can be persuaded by relevant authority from anywhere, really, but obviously we tend to use, for the purposes of persuasion, courts in England and Wales, Australia, Canada and the US predominantly. And then we have a tiered system in civil law. There are actually 5 levels of courts, from the district court, circuit court, high court, which used to have full original jurisdiction. And since 2014 we have a civil and criminal court of appeal, which allows the Supreme Court to do what the Supreme Court does here, which is to pick its own cases and deal with those. So the common law, most of you will probably remember this from your university days. The comparative theory of legal origin holds that institutions depend on political factors. So Hayek said that the ideal of individual liberty seems to have flourished chiefly among people where, for long periods at least, judge-made law predominated. And this is a scholar from Chicago Law School in 2001. Comparing the common and the civil law by reference to England and France. And it's an interesting theory that the common law developed because landed aristocrats and merchants wanted a system that would provide strong protection for property and contract rights and limit the Crown's ability to interfere. French civil law developed because the Napoleonic generation wanted to prevent judges from thwarting government centralised economic policies. We, in the wake of the referendum result in the UK in 2016, were asked, as the legal profession and led by the bar, to look at the way in which the common law operates with a view to seeing whether there are any opportunities or benefits for Irish law, bearing in mind that for the last 35, maybe 40 years, English law has become a major source for dispute resolution. It's incorporated widely into contracts around the world, together with New York law as the principal choice of law for resolution of disputes. We discovered, and in fairness, it doesn't take much to discover this, but we discovered that obviously global business trusts the common law much more than it trusts the civil law. Stare decisis actually makes it easier for lawyers to predict outcomes, those who are advising their clients, and it initially to us seemed a little bit like a contradiction in terms of if you've got a civil system where you make provision for practically every single eventuality, it should be possible for a lawyer to advise in a dispute. But in fact, that's not the case because, as some of you will probably know, the German civil code and the French civil code are full of abstractions that are very, very difficult to comprehend. And in fact, each and every case is decided by a judicial type decision maker on the basis only of the facts in the specific case that's sent up to them, often on paper, and with almost no capacity for persuasion on the part of the lawyers. So one of the things that happened after 2016 was that a number of member states started to do some work on trying to encourage common law business in the area of dispute resolution to their jurisdictions. And I'll come back to this perhaps in a couple of moments, because it's something that we looked at also, and it's something that we thought was a little bit strange. But before I do that, I just want to have a look at a few issues relevant to common law and civil law. And I suppose that the theory is, or the thesis is, that the systems have benefited hugely from their coexistence since Ireland and the UK joined the then European Economic Community. It can be seen in a whole variety of areas. It can be seen in the common law, and it can be seen in the civil law to a certain extent. Particularly when you look at the civil law, it can be seen in the way the common law has had an influence on the law of the European Union. So obviously some examples as to how this has happened: typical civil law concepts like proportionality and effective remedy, which is a big one in France, have crept in to certain aspects of the common law. The obligation to state reasons in decision-making, particularly in the public law sphere, legitimate expectation, and now because in the manner in which you implement European law, Article 6 of the Treaty on European Union incorporates fundamental rights into the Treaty on European Union, and it requires effectively member states, when they are implementing European measures, regardless of whether they're using a common law system or a civil law system, to have regard to fundamental rights. Looking at it perhaps a little bit the other way around, there are significant differences in the way the EU has been influenced by common law concepts. It's not surprising, I think, that it's seen at its most effective in areas like commercial and financial regulation and disputes. There is a divergence in principle between northern and southern states. Some of the Nordic countries have taken on board a lot of the notions of commercial law that exist in common law countries, and they're not quite as wedded to the pure civil code as, say, the French and Germans are. Financial regulation is another area where you've seen huge influence on the part of the common law, and in particular the City of London. And I'll come back to that in a moment, because it's very relevant, I think, to an issue that we are concerned about. The 2004 merger regulation contains within it provisions that would be very familiar to common lawyers. And then, from the point of view of sort of practice in the European courts, it's a subject close to my own heart. Obviously, judicial dialogue. Civil law judges tend not to engage in dialogue with one another. Certainly not to the extent that happens in common law systems, but the notion of preliminary references and the interaction that often occurs between the courts in Luxembourg and the national courts who have sent the questions is and has been developed incrementally over the years, and is something that is very, very important. Oral advocacy at the Court of Justice, one of our great fears is that with Brexit we lose this. There is a view that a lot of civil lawyers, and this is because of the way that they practice, they don't tend to do oral advocacy in dispute resolution, at least not in civil cases. So oral advocacy at the European Court of Justice tends to be the preserve of lawyers from common law countries, and having sort of personally witnessed this on many, many occasions, the quality of oral advocates from England and Wales and from Ireland tends to be an awful lot higher than the quality of oral advocates coming from the various member states, and that's from the other member states. And that's, I suppose, not surprising. What would be a worry is if the court decided to downgrade oral hearings at the ECJ in the wake of Brexit, because again, you have a very large member state with a common law tradition of oral advocacy, which is no longer in play and no longer agitating and requesting that these things be done. Judicial precedent, again, something that's now embedded in European law. The Court of Justice, in reality, follows its previous decisions. What was previously the Court of First Instance, now the General Court, is and regards itself as bound to apply the law as interpreted by the Court of Justice. So you have a system of stare decisis in effect with regard to principles of European law, unless you can find some real reason as to why, as opposed to a theoretical one, as to why that shouldn't be so. So another example of the common law influence on European law, all the way back in 1974, Advocate General Warner, commenting on the ad alteram partem rule, again attempting to try and make it sound as though it's not unheard of in France, but I don't think anybody really agreed. Rule of natural justice, but maybe it's similar to the principe généraux de droit in France, I don't know. Solvay in 2011 is a very important case in the context of European law because there is no, as again you'll all probably know, there is no system of document disclosure in civil law systems worth speaking about. And indeed, even in public law challenges, there is little in the way of requirement for authorities and decision makers to disclose documents. Solvay was a case in which the Court of Justice overturned decision of the European Commission in a competition case because the Commission withheld information that was on the file that might have been capable of assisting in promoting the principle of the rights of the defence. And the court said that the test isn't, that is the document relevant or not relevant. It's actually a test which some of us would be familiar with. So it's easy to show, I think, that in the absence of the procedural irregularity, the contested decision would not have been different. There was even a slight chance that the availability of the documents would have made it better for the applicant to defend themselves in the context of the regulatory decision procedure. So, Brexit. Right. Okay, nobody really needs to know about how profound the economic effects are going to be. We've been hearing about that for a long time. I have to say, I've spent a lot of time over the last couple of years talking about Brexit all around the place. Most of the things or panels I was on, there was discussion, a lot of discussions, most of the type of which I don't think I could reasonably repeat here. But, and I hit the wall about 6 weeks ago. I mentioned this earlier to somebody because I've been following this obviously very closely, but about 6 weeks ago when the Parliament in Westminster kind of changed, the deal was not the deal that was negotiated anymore. I switched off the television for a couple of weeks at that stage because I'd had enough, and I think everybody was kind of exasperated with what was going on. The Northern Ireland issue is extremely complicated, and I'm not certainly going to try to suggest how you get it resolved. Simply just to say, as a matter of fact, it's two agreements with three strands. Strand one is the northern parties and how they regulate their business within Northern Ireland and how they govern. It's stalled at the moment, but it does explicitly require, and did explicitly require, the incorporation of the European Convention on Human Rights into Northern Ireland, which was done, and it applies. So again, strictly speaking, not an EU law issue, although an awful lot was said in the run-up to the referendum here about the European Convention on Human Rights and what it really meant and what this would give us an opportunity, or give you an opportunity to do in the UK, get rid of it. Even if that is the case, it can't be got rid of in Northern Ireland because it's explicitly referred to in the agreement. The second strand is a strand which relates to what are described as cross-border arrangements. There are 12 cross-border bodies. They deal with a whole variety of things, from tourism to fishing, to some promotional work and some technical things. They refer, again, the treaty refers specifically to EU dimensions and programmes and how they are to be implemented by these cross-border bodies. And thirdly, the third strand is the binding international treaty between Ireland and the UK, which again commits, in I suppose relatively vague terms, to the partnership in the context of the membership of the European Union. That's probably something you could mess around with, I think, because it's a vague aspirational description. In fact, the treaty itself is largely vague and aspirational in that sense, but it is a binding international treaty, and it has been invoked by those who say that you can't have a hard Brexit and have the Good Friday Agreement in its current form. I'm not sure that the third strand gives you that argument. I do think the second one does. Certainly 2 years ago, myself and the chairman of the Northern Ireland Bar did a panel at the English Bar Council's conference, and we discussed all of these things, and I think we came to the view that even if you had competent, clever, committed politicians trying to figure out how to fix it, you probably would struggle to do it. But I'm not sure that they're in great supply at the moment. So Brexit downside for us, the Court of Justice of the European Union, as I said, it's going to lose its dialogue with the courts of the United Kingdom, particularly England and Wales in the common law sense. And that's a problem for us because we, again, tend to piggyback a little bit on what's happened in England and Wales. We've relied on, over the years, because we're small, not as well resourced, we've relied on the greater resources of the Treasury Solicitor's office here and the government departments here to keep an eye on what's happening in European law, including to keep an eye on what's happening with cases before the Court of Justice. We're going to have to spend an awful lot more money now on that, and it's something that our government is committed to try to do, but it remains to be seen whether that will work. The traditional oral advocacy skills of the court I've already mentioned. And I suppose perhaps not to be understated from the point of view of the downside for us, but ultimately I think a downside for the court, is there is a large number of personnel working in the European courts who are UK citizens, and they bring vast majority of them are lawyers, they bring a common law perspective to European judicial decision-making, again, I think it would be very, very unfortunate if we were to lose all of that. So we think that will result in ultimately a diminution in the common law influence over time. The current President of the Court of Justice, Colin Lennox, is a great believer in oral advocacy and oral hearings, but obviously judges come and go, and the next round of senior judges at the court might have a very different view. So from our perspective, as I said, we can see civil law encroaching onto the common law via European rules, a Europeanisation of commercial law, and one of the examples of that, and I'm going to come back to this in a little bit more detail in a moment, is the Common European Sales Law, which was an example of how the UK successfully fought off a civil law concept. So will this result in the de facto legal isolation of Ireland? There's reference, I think, to Malta and Cyprus as being slightly kind of common law-ish jurisdictions, or at least half and half in some respects. But I think we would be concerned that we would be the only real, or at least the only exclusive common law jurisdiction in the European Union. There is a precedent in the United States. Louisiana is a civil law jurisdiction. It derived its civil code from the Spanish originally, and then taken over by the French, and it has managed to survive, or at least a large portion of that have managed to survive, despite being surrounded by 49 states with a common law jurisdiction and background. So the Common European Sales Law was an idea mooted by the European Commission in 2009, 2010, and it purported to import into contract law civil law principles. And the really problematic one, I think, is good faith and fair dealing, concepts that are very familiar to French civil lawyers. These were the plans. Article 2, parties had a duty to act in accordance with good faith and fair dealing. That would then have to be interpreted by decision makers in breach of contract type claims. Pre-contractual statements can be incorporated into the terms of the contract, again, something that would be anathema to common lawyers, particularly those who practice in this area. And Article 89, a duty on parties to enter into negotiations when the performance of their obligations under the contract became what's described as excessively onerous. Again, a concept familiar to French civil lawyers. There was a pretty strong reaction to this from, not just in fairness, the City of London. I mean, Irish and to a certain extent some of the Nordic countries were very reluctant to engage with it. The proposals were described as vague, wide, uncertain and unpredictable. You can see, obviously, how they're impossibly to comprehensively define. They tend to undermine the notion of freedom of contract. And it's certainly the case that, and certainly the belief was, and I think there's no doubt about this, that they would result in a huge number of additional disputes, particularly in and around the understanding of the good faith principle. So this is what the UK government said back in 2010, and there wasn't a proposal at the time that there would be even that the Court of Justice, for example, would be capable of uniformly interpreting the notion of good faith. So this kind of Esperanto idea was dreamed up by the Commission at the time. But the UK reaction is actually quite a good summary of what was being planned at the time. It's difficult to quantify this, but a 29th regime, and that's a reference to the fact that there were 27 member states operating similar systems, and Scotland, because Scotland operates a civil law system, so there'll be a 28, and then a 29th regime of contract law would belong to no one in particular and wouldn't reflect any particular heritage. And then there's an argument about, well, maybe you should start off by saying the only way you can interpret this is base it on the common law perspective, because it's the most commercially attractive approach. And the Esperanto approach must raise the possibility that it will feel comfortable and familiar to no one, and consequently will be rarely used. That actually did do for that, and the opposition of certain member states, but particularly the City of London, was very good at mobilising the UK government at the time against it. That did for it at the time, but Emmanuel Macron in 2017 said this: unified civil law is inevitable for France and Germany. What he really meant was for the European Union after Brexit, because there'll be nobody left really to fight with us about these things. And that, again, I suppose, is a concern, although, I suppose, just to give you the alternative perspective, it's not, you can't see the quote. This is, I'm going to give you two quotes from one of our leading constitutional and European scholars, judges, Gerard Hogan, who managed to make the transition from academia to huge practice at the bar to very senior judge in our Court of Appeal, and as of last year he's now our Advocate General at the Court of Justice. But he has some insights into the concept of the good faith principle, and he says, well, maybe, you know, down the line you can see, if it's not an objection per se, you can see the possibility of it creeping into our law. And in the same year, in a different case, he said this: it's only a matter of time before common law courts come to recognise the existence of a general duty of good faith. If that were to happen, it would presage a similar development in our law at some later stage. It could not, however, authorise the courts to undermine the substance of the rights and parties and obligations of the parties to the contract in reliance on such a general principle of good faith. So again, you can see arguments on both sides in relation to it, although I think the vast majority of my colleagues and I would be concerned about what that might mean for the future. So Brexit and practice of law, this is a source, I suppose it's a bit out of date now, but and it might have been, some of it I think can be put down to the slightly more hysterical reaction to the referendum result at the time, but in 2016, after the referendum, a lot of law firms expressed concern in the UK about the absence of passporting into the single market, future operations and headcount issues. We've seen a very large number of solicitors joining the role of solicitors in Ireland. Something like 1,500 in the last 2 years. Very, very few of them have actually gone the extra mile and taken out practicing certificates. We at the bar changed our rules slightly 2 years ago so as to make it easier for practicing members of the English bar to become members of the Irish bar. We had a pupillage requirement and a CPD requirement that we got rid of because we were talking to some of the chambers that specialise in European law, and we could see how it would benefit them if they had an opportunity to avail of practice in another member state. We don't warrant as to whether it works or not. There will be fights about this, I suspect, down the line Brexit happens the way it's due to happen. Whether you can brass plate in one member state and avail of treaty rights to provide services, not sure. I think the reality is you'd have to be involved in some sort of effective availing of the right to provide services in order to do that under the directive, but it's certainly a possibility. And we've had about 200 English members called to the bar, and about 50, I think, have joined the bar in the last couple of years. Obviously, those rules don't change, so if Brexit is extended or delayed, there will be further opportunities for members of the bar here to join the Irish bar. So again, it's, this is the issue about other European cities rivaling London. So we launched a project in January 2018 with the support of our government to promote Irish law. And I think it's important this is seen in the context of what clients are telling lawyers that they want to see happening, arising from concerns about things like Brussels II, things like European Central Bank regulatory and establishment requirements. The International Swaps and Derivatives Association last year recalibrated their standard form contract. They're the only show in town, apparently, for swaps and derivatives worldwide. It was the case that you could only choose New York or English law in their contracts, and they added French and Irish law last year because of a concern that a lot of the clients had about the ability to enforce contractual dispute results in the EU if Brexit goes badly wrong. Competition issues, there are either plans afoot or they have been implemented to establish various types of English language courts in Paris, Amsterdam, Frankfurt and Brussels. They've had an English language chamber in the Frankfurt High Court for a while. Amsterdam has started in January of this year, the Netherlands International Commercial Court, and the French have spent an awful lot of money marketing what they describe as a common law English language dispute resolution court in Paris. Although we've looked at it, and we've looked at it in conjunction with a lot of colleagues in the Bar Council in England and Wales, and we're frankly very sceptical about its capacity for success, not just because it's French, but because that brings with it a whole variety of additional difficulties. For example, and this is the obvious first step, the French Constitution requires all the judges to be French, so they have to train them to speak English and train them in the common law. There is no provision for an English language appeal to the Cour d'appel in the proposals, so you can see how there might be some difficulties with it. But again, this is what we are looking at, and I think it's important, and we've always said this, this isn't about competing with London, this is about competing with those whose clients are telling them, I can't do this in London because the ECB says I can't, or Brussels II hasn't been redone. And ironically, Brussels II emanates from a regulation which predated 1967, 68, 67, which predated the accession of the UK and Ireland, but it's now become embedded in European law. There may be ways around that. Arbitration is a good answer to a lot of these things. Obviously, it works in certain areas, it doesn't work in others. And these are the things that we've been saying about Ireland. Common law, English speaking, business friendly, outward, globalized, and I think that's a view, I think, of our society and economy generally. We've had far too much of narrow-minded nationalism in our country to want to suggest that that's a good way to do your thinking in the future. We have a very, very respected judiciary and a very efficient commercial court. It's not without some difficulties, there's no doubt about that. I think, as we'll hear, there are lengthy delays in relation to our Court of Appeal, and again, the government has committed to putting in place new measures, financial measures, to try to improve that. And of course, we would say that we have some fantastic lawyers who are brilliant at doing everything that they're asked to do in a whole variety of areas. So I suppose the answer to some of the questions then is, if you're looking for friends in the aftermath of Brexit, Ireland is the place to go. The links between the Irish Bar, as Master Berger said, and the Irish Bar and the English Bar are very strong historically. About 400 members of our bar are also called here. And we believe, certainly at a leadership of the bar level, we believe that, and I think our judiciary feels the same way, we should maintain very close links with our colleagues here, whether through mutual recognition, joint events, exchanges, and so on. We do quite a lot of work with both the council and through the inns events and things. So I mean that's certainly on the cards, and I think in spite of Brexit, or maybe even because of it, it's something that we should be looking at in the future. So thank you for listening. I hope that you don't feel the same way that a very uncharitable colleague of mine did a couple of years ago after I was elected chairman of the bar. This bloke, must have been a bloke, put up a notice in the gents' toilets in the law library in Dublin. It was stuck beside the button on one of those automatic hand drying machines, and it said, "Press here if you'd like to hear a short speech from the chairman." Thank you.
Thank you very much indeed, Paul, for an admirable tour d'horizon of quite a complex range of issues delivered with commendable clarity. It left me actually feeling, which I didn't expect to feel at all, a slight emotion, namely a slight sense of guilt for leaving you in the lurch as the sole standard bearer for the common law when faced particularly with the French, seeing that you did identify them. So that guilt's only tempered by the fact at the end it was quite clear that you do sense enormous opportunity in the possibilities which that opens up for you. We have got 5 minutes now or so for questions. And actually I can see a couple of microphones at the back which, yes, no, sorry, people have stood up. They will appear in front of you if you raise your hand if you would like to ask a question. I'll keep talking aimlessly for a second until somebody does, in fact, raise the hand. There we are. Yeah, thank you.
First, I'd just like to add my thanks for that lecture. I especially enjoyed the reference to Friedrich Hayek. My question is, if you don't have chambers in the Republic, how does pupillage or that stage of training work? And is it superior to how pupillage is done in the UK?
I certainly don't think I could say it's superior. It's different in that pupils are required to attach themselves to an experienced junior counsel. I think the minimum is 10 years practice as a junior counsel for 1 full year or 1 full legal year, during which they follow that person around effectively as their pupil, individual pupil. And that's an obligatory requirement. And then the vast majority of pupils then do something similar in a second year, usually with a different type of practitioner and sometimes with more than one practitioner on a more loose or informal basis. But I think 99% of them would do 2 years, the second year on a voluntary basis, because that's the way in which they get to meet with solicitors or corporate counsel or that type of arrangement. So it's different in one sense in that everybody gets a master, and the way in which it's organised is fairly relaxed. People in Dublin change what they do quite a lot, so you know there's no real trick to it. And there certainly is very little in the way of contacts or connections playing into it. It's generally operated on a first-come, first-served basis. Certainly in my case, I was asked a couple of years in advance by most of them, and I took the first person that asked me. Most of them get a go, and as a result of that, there isn't the same scramble for or the need to be in certain types of sets in order for that to make a career. But I think that the drop-off rates are probably the same from people qualifying, because the work isn't there for everybody. I don't know if that answers the question. I certainly wouldn't be qualified to say that it's better or worse.
Yeah.
Thanks. This is a bit technical, but would you be able to explain to us why Strand 2 of the Good Friday Agreement seems to require something like the backstop? I mean, I think everyone can see why special arrangements for Northern Ireland might be desirable depending on your perspective. But some people argue that actually it's not just desirable, it's necessary in order to comply with treaty obligation under the Good Friday Agreement. And for my part, I've not been able to understand why that is. So I wondered if you could throw some light on that.
It's not as easy to explain as, well, clearly it's not easy to explain. And it certainly does come down to interpretation, and it often comes down to a view. The text of the agreement refers to the cross-border bodies and refers specifically to their implementation jointly of a number of EU programmes. It doesn't go into detail in relation to it, but that's certainly one of the reasons that have been advanced by those saying in order for that to be maintained, you can't have a border because that would presage different regulatory regimes operating on both sides where they might be covered by cross-border bodies. I mean, I don't have the list in front of me, unfortunately, but there are certain areas where fishing is one that I'm familiar with because it's been topical in the last while, and I've been involved in some case law involving fishing in Northern Ireland and Southern Irish vessels. But there's a view certainly amongst lawyers that you can't keep the Good Friday Agreement and have a hard border because of that particular part of the agreement. And there are those who take it a lot further and use the aspirational words in relation to in Strand 3, and obviously there's the ECHR argument as well. But yeah, I mean, I think a lot of, again, I'm the last person who should be asked about this, but there is a lot of stuff talked about the Northern Ireland backstop, which seems to be generated more from, I think, a position of political either necessity or view or standpoint, because it suits people to say it in a certain way. I mean, I find it somewhat ironic that all of what I might describe as traditional unionist business and farming communities in Northern Ireland are very, very strong in their view that there must not be a hard border, and that the backstop, insofar as there, is the only thing that's going to work, for the moment at least. And yet the political representatives of a lot of those types of people seem to be saying something very, very different. But again, that's an internal political Northern Ireland issue. It's a difficult one to understand, but it's like a lot of these things, it's extremely difficult to understand, to me. Sorry if that doesn't answer the question.
More. I'll just say on that, I think actually the backstop and the interrelation of the Good Friday Agreement probably become the Schleswig-Holstein question of our time. I'm delighted somebody else found it difficult. More, yeah.
I would just like to ask a more general question about what you see happening in the future. As a member of the bar here and a member of the bar in Ireland when I was in practice, now a judge here and a member of Middle Temple, where we have historically very strong links with the Irish. Irrespective of the competition, which is no bad thing and has always existed between London and Dublin, do you think that the way that Dublin is going to have to go to take advantage of what's likely to happen here is likely to bring us closer together or further apart?
I think closer. I mean, certainly the aspiration that many of us have is that it would bring us closer together. And again, it's an issue that's cropped up in some discussions between the bars, that in the wake of we obviously have a relatively seamless system for cross-qualification, so you can qualify. In fact, it's actually slightly easier if you're an Irish barrister to become a member of the English bar than it is if you're an English barrister to become a member of the Irish bar, because you have to do a couple of very straightforward tests, whereas we don't. But I think, but the reason for that is because it's dependent upon European directives, and that's the implementation by the regulators of European law under establishment. But I believe that it's incumbent on us to ensure that in the wake of Brexit, some alternative mechanism is put in place to allow for the seamless transition or mutual recognition of, as certainly between us and England and Wales. Now, whether that can be done in the context of European law and services, provision of services, I don't know the answer to that, but I would have thought that if you can have arrangements to recognise Australian lawyers subject to certain conditions, you can have bilateral arrangements with New Zealand lawyers or whoever. I don't see why it wouldn't be possible to have bilateral arrangements between Ireland and the UK. Regulators would have to be involved, obviously, but I can't see any reason why there would be a problem with it, and I think it's a good thing. I also think that one of the reasons why we changed the rules in the last couple of years, and we've actually tried to encourage more practitioners from England and Wales to become members of the Irish Bar, not just those who see their entitlements to practice in the European Court of Justice being somehow impinged upon by Brexit. We think that if you have good clients who want to come, you will get good lawyers who want to come, and there will be more good work for everybody, if you can follow the logic of that. And we genuinely believe that it will be of mutual benefit if that happens. But I do think that we should have, and we should work more closely together to try to ensure that there is greater mutual recognition and qualification and capacity for practice after Brexit. Yeah.
This being an essentially Irish occasion, my main duty is to draw stumps before we impinge on drinking time. We're about to do that, so I think we should draw things to a close. For those of you whose appetite for things Irish has been whetted, there is in Temple Church on Wednesday week, the 20th, choral evensong, 5:30 p.m. to celebrate St. Patrick. If spiritual nutrition is inadequate for you, actually afterwards you can have a free pint of Guinness in the round. Those who wish to come just for that will be just as welcome as those who are coming to worship. So Paul, it merely remains for me to say thank you very much for coming to speak to us with such admirable clarity. You have definitely earned your drink, and I for one will be enthusiastically joining with you in there to have it. So please could we thank Paul again for his